Hi, very good morning. This is a Supreme Court judgment under the Customs Act, read with the DGFT, Director General of Foreign Trade. Citation is Veeraj Impex Private Limited versus Union of India. Facts of the case: Veeraj Impex Private Limited, hereafter I will refer as VI. VI is an importer and trader of mild steel. Prior to February 2016, the items were freely importable under the Foreign Trade Policy 2015 to 20. So prior to 5th February, I'm sorry, prior to 5th February 2016, VI entered into firm sale contracts with exporters in China and South Korea. On 5/2/2016, VI opened irrevocable letters of credit in favor of the foreign suppliers. On the same day, that is on 5/2/2016, DGFT, that is Director General of Foreign Trade, uploaded a notification on its website. It introduced a minimum import price for the items to be imported by VI. In that notification itself, DGFT said that this notification is to be published in the official Gazette of India. That is one remark that was appearing in that uh, notification, which was uploaded in the DGFT website. Finally, the notification got published in the official Gazette only on 5 to only on 11/2/2016. So, anticipating this restriction, uh, VI on 8/2/2016 applied for registration of their LC under Transitional Protection Clause of Foreign Trade Policy. They approached the High Court with a writ petition that the notification cannot apply to imports covered by the LCs prior to publication of the notification, that is on 11/2/2016. That is the date on which the notification was published in the official Gazette of India. They prayed to the High Court for quashing the notification. Alternative prayer was made. They prayed to the High Court saying that this notification will not apply to imports covered by LCs prior to 11/2/2016 because they registered their LCs on 8/2/2016. High Court held importers had sufficient notice of the notification because this DGFT put it on the website on 5/2/2016. So you had enough notice. Hence, even though the notification is published in the official Gazette on 11/2/2016, it will apply from 5/2/2016 itself. That is what the High Court said. So the High Court order was challenged before the Supreme Court by way of SLP. The issue before the Supreme Court was, what is the date of notification? Is it 5/2/2016? That is the date on which the DGFT uploaded this notification on the website, or it is 11/2/2016 on that is the date on which the notification was published in the official Gazette of India. That was the issue before the Supreme Court. Supreme Court said law to bind must first exist. To exist, it must be made known in the manner prescribed by legislature. Unlike a plenary legislation, that is an act of parliament, enacted by parliament, delegated legislation is framed in the executive chambers without open debate. The publication of notification serves two purposes. The notification in the publication in the official gazette serves two purposes. One, it ensures accessibility and notice to those governed by law. That is point number one. Two, it ensures accountability and solemnity in exercise of delegated legislative power by the executive. Hence, act of publication in Gazette is not an empty formality, but it is an act by which executive decision is transformed into law. That is why courts have held prior decisions, Supreme Court decisions held, that publication in the official gazette is a condition precedent for enforceability of delegated legislation. The legal position in this regard is that natural justice requires that before a law can become operative, it must be promulgated or published. It must be broadcast so that all men know it, or at the very least, such knowledge can be acquired with exercise of due and reasonable diligence. Supreme Court said that in the present case, the Parent Act mandates that any order regulating imports or exports shall be made by an order published in the official gazette. Hence, the notification could not have acquired the force of law prior to its publication in the official gazette, that is on 11/2/2016. The notification itself, published by the uploaded by the DGFT in its website, acknowledges that the notification is to be published in the official gazette. Till the time of publication, the notification has not crossed the threshold from intention to obligation. Till such time it is published, it remains only an intention. Once it is published, then it becomes an obligation. In law, a notification is born only on its publication in the official gazette, and from that date alone, the rights may be curtailed or obligations can be imposed. Further, the Supreme Court said the benefit of transitional provisions prescribed under the FTP cannot be denied to VI. The court reasoned that imposition of fiscal burdens would erode commercial confidence and offend the rule of law, the result of which the court must steadfastly guard against. Supreme Court held in this case the date of notification means date of publication in the official gazette, that is 11/2/2016. It granted the benefits to imports committed by LCs made by VI before 11/2/2016. Supreme Court quashed the order of High Court. That is what the order of Supreme Court says. Thank you very much. Have a great and wonderful day. Bye.